Hello, my name is Sue Miller, and together with Ed Davis, I head up the Banking and Financial Services Litigation Group at Stephenson, Harwood. Welcome to the second in our autumn 2016 series of 4 short webcasts, in which we take a bite-sized look at some of the key themes emerging in financial disputes over the last 12 months. In today's webcast, Ben Sigler, a senior associate in our Banking and Financial Services litigation team, will explore the legal impacts arising from negative interest rates, in particular in relation to loan agreements and swaps, and the steps which might be taken by market participants to address these impacts.
Welcome to our webcast on negative interest rates. In this talk, I'll provide some background on negative interest rate policies, or NIRP, and how they've impacted interbank rates, commonly referred to in financial documentation. I'll also provide a summary of some legal implications, focusing in particular on loan agreements and swaps, and some thoughts as to steps which might be taken by market participants in light of these implications. We're in the midst of a new era in monetary policy, defined by the widespread deployment of nominal negative interest rates on excess reserves held by commercial banks with central banks. Central banks have applied such rates in order to stimulate demand and lending, or to devalue their currencies. Whilst historically there are precedents of the use of NIRP, the current scale of its use is unprecedented. A quarter of the world economy was subject to NIRP in mid-2016. NIRP has, in turn, led to various reference rates turning negative. The Bank of England has not instituted NIRP. Whilst Mark Carney has made clear his opposition to NIRP, other members of the Bank of England's MPC have not ruled it out. It therefore remains at least conceivable that the Bank of England may one day impose NIRP, triggering reference rates referable to sterling to become negative. As NIRP are now well established, standard form documentation used in financial markets has been revised to provide for negative reference rates. For example, the introduction in May 2014 of the ISDA 2014 Collateral Agreement Negative Interest Protocol and the introduction during 2012 of optional zero floor wording into LMA documentation, meaning that where the reference rate becomes negative, it's deemed to be zero for the purposes of the loan agreement. If appropriate revisions are adopted by market participants, the parties' rights and obligations where reference rates become negative ought to be clear. By contrast, where transaction documents were prepared prior to the introduction of such revisions and do not incorporate them automatically, or where those prepared thereafter fail to incorporate them, for example due to a failure to revise standard form documentation, contracting parties may be exposed to uncertainty. Negative reference rates will impact legal relationships between all market participants and may also give rise to a range of regulatory, tax and operational issues. Given that this talk is only intended to provide an introduction to the legal implications which may arise from negative reference rates, I'll now focus on those implications in the context of loan agreements and swaps. If a loan agreement contains a zero floor, where the reference rate becomes negative, the lender will be entitled to recover the agreed margin, regardless of the reference rate. However, the situation is not clear-cut when no express provision is made for negative reference rates, which is, for example, the case in most standard variable rate mortgages. In such circumstances, if the reference rate becomes negative, this will erode the lender's margin, potentially to zero, and, at least theoretically, leave the lender exposed to making payments to a borrower. It is unlikely that any loan agreement would contain an express obligation requiring the lender to pay the borrower interest in the event that the reference rate was negative in an amount exceeding the margin. However, it's possible that a loan agreement might contain ambiguous wording regarding the treatment of interest, which could be argued to have this effect. If the English court was asked to determine whether this was the case, its analysis would be based on standard principles of contractual interpretation and would primarily turn on the precise wording of the relevant provision. Alternatively, an argument could be advanced by a borrower that a lender pays borrower clause ought to be implied into the loan agreement. The Supreme Court recently provided guidance as to the circumstances in which terms will be implied into a contract, emphasising that the term must be necessary to give business efficacy to the contract, so that a term will only be implied if, without it, the contract would lack commercial or practical coherence, or the term must be so obvious that it goes without saying. The term must be capable of clear expression, the term must not contradict any express term of the contract, and the term must be fair, and, if it had been suggested to the parties, they would have agreed it. It was emphasised that the court's approach to implying terms remained highly restrictive. Given this highly restrictive approach, it seems unlikely that the English court would determine that a lender pays borrower clause was implied into a loan agreement, regardless of the level of the borrower's sophistication. The more likely result would be that interest would not be payable by the borrower to the lender. However, this issue is yet to be tested before the English court, and there remains a possibility, albeit remote, that the court could conclude that in certain circumstances a lender pays borrower clause was implied. Matters of relevance to its analysis might include the borrower's characteristics, the specific wording of the loan agreement, the circumstances in which the loan agreement was entered into, and the existence of and terms of related transactions between the borrower and the lender. Other national tribunals have, in fact, held a lender pays borrower clause to be implied into loan agreements. The Netherlands Consumer Financial Products Watchdog, CIFID, recently held that a lender, Achmea NV, should pay consumers interest for the entire period in which the negative reference rate exceeded the margin, despite the fact that the relevant loan agreements referred only to a payment obligation on the part of the consumers. By contrast, in order to preserve its margin, or in response to an argument by a borrower that a lender pays borrower clause ought to be implied, a lender might argue that, to the contrary, a zero floor should be implied, which Achmea NV unsuccessfully attempted to do before CIFID. Again, given the English court's highly restrictive approach, such an argument would appear difficult, in particular where loan agreements have been entered into on a lender's standard terms. Alternatively, assuming that the loan agreement contained appropriate terms, a lender could attempt to invoke provisions entitling it to calculate interest by reference to additional funding costs to which it is exposed by virtue of the negative reference rate. Whether a lender would be entitled to do so would turn on the wording of the agreement and specific factual circumstances. If a swap incorporates the 2006 ISDA definitions, the parties may use either the negative interest rate method, the default position, or the zero interest rate method. The negative interest rate method provides that, where the floating rate is negative, the fixed rate payer pays the counterparty the negative reference rate in addition to the fixed rate. By contrast, where the parties use the zero interest rate method, a zero floor is imposed on the floating rate, and the fixed rate payer is only obliged to pay the counterparty the fixed rate. However, the fixed rate payer is likely to have to pay a premium to the counterparty for this protection. Issues will arise where parties have entered into a loan agreement and a swap which adopt inconsistent approaches to the treatment of negative reference rates. Where a zero floor is included in a loan agreement but not in the swap, where the reference rate is negative, a borrower will be exposed to paying both the fixed and floating rate under the swap and will not receive a payment of negative interest under the loan agreement, leaving them exposed. The protocol provides that if the reference rate for an interest period is negative, the transferor, the collateral poster, pays the transferee, the collateral receiver, interest on collateral posted for that interest period. Only some market participants have adhered to the protocol, and even where the parties have done so, this does not mean that the protocol will automatically apply to a particular credit support annex. Where swap agreements are made by reference to credit support annexes to which the protocol does not apply, it's arguable that where the reference rate is negative, interest may be payable on the same basis as under the protocol. The true position is unclear, as recognised by ISDA itself, and the English court has yet to provide guidance on this. However, the better view may be that the transferor is not obliged to pay interest to the transferee, leaving the transferee forced to bear any losses arising from the negative reference rate. Where parties suffer losses as a result of the unanticipated impact of negative reference rates, they may be entitled to advance claims in negligence against any professional advisors retained to advise them. Furthermore, where lenders or swap counterparties were obliged to, or did, provide advice regarding the suitability of such transactions, they may also be exposed to claims in negligence. Alternatively, claims for misrepresentation might arise against them in circumstances where they provided misleading information in relation to the transactions. Potential steps which market participants might take to mitigate risks arising from negative reference rates include reviewing all existing documentation to identify potential exposures, and where such exposures are identified, considering whether to approach counterparties to agree relevant amendments. Such amendments could include, for lenders, the inclusion of zero floor wording, or the inclusion of a provision that the lender is, in no circumstances, obliged to pay the borrower interest. And, for borrowers, wording providing for consistent approaches to the treatment of negative reference rates between the loan agreement and the swap. Parties may also wish to consider entering into further transactions to hedge any exposures identified where it's not possible to negotiate amendments to relevant documentation. Where losses crystallise, parties may wish to consider claims against their professional advisors or their counterparties as appropriate. Finally, parties will wish to ensure that relevant protections are included in all documentation prepared in relation to future transactions.